follow up on a couple of the questions Chairman Gowdy asked. Your texts and emails make it appear you'd come to a conclusion on the Clinton case long before you had interviewed many witnesses, including Clinton herself. You also appear to have been pining for the impeachment of President Trump at the very beginnings of the Russia case. Does the FBI normally make such decisions on whether to recommend prosecution or exoneration so far ahead of all the facts coming to light?
Typically, sir, DOJ makes prosecution decisions in cases.
Do they normally make such decisions and whether to recommend prosecution far ahead of the facts coming to light?
Sir, I don't think any decision, in my experience, the final decision is never made until the conclusion of the case. I think it is fair to say that in the conduct of investigations, particularly very large investigations with a lot of folks working on it, my experience is there comes a time, if you're worth your salt in the conduct of that investigation, an agent, the attorneys assigned to that will have a very good idea well before the case is concluded that there may or may not be demonstrable crimes, that there may
Let me ask you this then. How many other cases on which you have worked do you recall opining on the disposition of the case months ahead of interviewing multiple witnesses?
I remember quite a few cases where I or agents would discuss the prospects of the outcome of the case with prosecutors as the case was going on. From the beginning of the case, talking about what crimes may or may not be relevant, as the case proceeded to identify which elements may or may not be strong or demonstrable, as well as towards the end when we were trying to shore up evidence that may or may not be there. But
and let me ask you this about that. In regard to those cases, was it normal behavior on your part to chat with colleagues in the manner you did on the Russia case about how much you despise the very person you're investigating, or complimenting the person you're investigating in the Clinton case? Is that typical?
Sir, I would draw a distinction between commenting on case-related matters versus discussion of personal belief. I think those are very different matters than saying this person as a witness was not credible, or this person as a target or subject did or didn't do something. That is a very different matter.
So you could completely separate out what your personal opinion is from what you discussed with others in investigations.
I'm telling you, sir, I separated out my personal belief from any
But you did not do that with
took.
regard to Attorney Page, who was also involved in these investigations.
Sir, I disagree with that. I separated out my personal beliefs from any action I took officially as an FBI agent every day.
Do you recognize how your vitriol against President Trump makes it appear you could never approach the case in a fair-minded manner?
Sir, of course I appreciate that. I understand.
So
that
let's
people would
discuss
look at
a text that hits home for me. On August 26, 2016, you texted Ms. Page, quote, just went to a Southern Virginia Walmart. I could smell the Trump support. And smell is in capital letters, all capital letters. What does Trump support smell like, Mr. Strzok?
Sir, that's an expression of speech. I clearly wasn't smelling one thing or the other. What I was commenting on is living in Northern Virginia.
What does that mean?
What I meant by that was living in Northern Virginia, having traveled 100 and 150 miles south within the same state, I was struck by the extraordinary difference in the expression of political opinion and belief amongst the community there.
And you described that as smell in capital letters.
Sir, that was a choice of the quick choice of words in a text.
All right. So earlier,
seen or heard.
Okay. So earlier, you had texted Ms. Page that another part of Virginia, Loudoun County, which is, I think, in Northern Virginia, is, quote, still ignorant hillbillies, end quote. Is that what you meant?
No, sir, not at all.
That you consider Trump supporters to be ignorant hillbillies?
Not at all.
What did you mean by that?
Well, sir, the first thing I'd tell you is a proud Fairfax County resident, there's a healthy sort of competition between Fairfax and Loudoun. Second thing I would tell you is that in no way did I or do I believe any resident of Loudoun County or Southern Virginia or anywhere else in the nation are any of those things. That was a flippant text.
So do you understand the implications of this text when my constituents in Virginia read it?
I do, sir. And I would ask you to tell them that that was in some cases, certainly unfortunate use of words, that in no way do I believe that those things are what.
Now, you and Ms. Page used personal phones and accounts to communicate. Have you turned over those communications to the Inspector General?
No, sir.
If not, why not?
Sir, they asked, and working with my attorney, the Inspector General and I arranged an agreement where I would go through my personal accounts and identify any material that was relevant to FBI business and turn it over. It was reviewed. There was none, and my understanding is the Inspector General was satisfied with that action.
We know from text that you and Ms. Page would transition to iMessage and Gmail. Who determined that messages were only personal in nature and not business related, especially since you've just testified at length that a number of the communications that you have made on government communications devices were personal in nature?
Sir, the broad context of what I used personal email and phones for was personal communication. For those things that were work-related, almost universally that material was translated into FBI systems. Certainly if it was anything that was a record or would constitute needing to be there, it was provided, but I made that decision.
So let me ask you this. When did Attorney General Lynch know that charges would not be brought against former Secretary of State Clinton?
I can't answer that question, sir. That's something you'd have to ask her.
Do you know whether it was prior to Lynch's announcement that she would defer to career prosecutors and Director Comey on whether to prosecute
Sir, I don't know.
Clinton? Why would Lisa Page text that Lynch's decision was a, quote, real profile in courage since she knows no charges will be brought, end quote?
So that's a question you have to ask her.
So how did you take that statement when she texted it to you?
The way I took that, sir, is that we had for many months working with a team of career attorneys in the Department of Justice, a team of attorneys from the Eastern District of Virginia, a team of agents from the FBI, been working intensively on this case. We had gone through mountains of evidence, tons of interviews, and we were looking at the various statutes that might apply to any sort of criminal conduct. And I think we were, as we surveyed that, as the attorneys looked at it, saw a number of very fatal areas where elements of the crime were lacking, our ability to demonstrate facts to prove those elements of a crime. So I think we had begun to arrive at a sense that it was going to be difficult, if not impossible, to identify any statute where we could satisfy those elements of the crime. My assumption certainly is that from the Department of Justice's perspective, those line attorneys were briefing their supervisors, who were briefing their supervisors, who were ultimately briefing the Deputy Attorney General and the Attorney General, and that she would have that same sense that it was a difficult, if not impossible, proposition to conclude that there were viable charges to be brought against Secretary Clinton.
Mr. Strzok, did you ever believe these texts would become public?
I did not.
Given that, you felt free to express your true feelings, didn't you?
I suppose, yes. That's a difficult question to answer.
Mr. Strzok, former Director Comey played judge, jury, and exonerator in the Hillary Clinton investigation. In your experience at the FBI, have you ever seen the FBI director make the decision on whether to prosecute for the Department of Justice?
Mr. Chairman, I would not agree with that characterization of Director Comey, and in answer to your question, I have not seen it before.
All right. Was that appropriate, what he did, to hold a news conference and publicly announce the decision that was supposed to have been made by the Department of Justice?
Sir, that was his decision.
Was it appropriate, in your opinion?
Sir, I don't think it's for me to say whether or not.
I think it is for you to say. I asked you the question. What's your opinion?
Sir, I understand the variety of factors that went into, well, I understand some of the factors that went into Director Comey's decision to make the announcement. I can tell you that that decision was not made lightly at all. I can tell you my experience in that decision.
But you're not aware of any precedent for that?
I'm not.
Mr. Strzok, in a footnote 197 of the Inspector General's report, it is noted that, quote, supervision of the Russia investigation was briefly transitioned from Strzok to another counterintelligence division, DAD, in early 2017. Why were you transitioned from the Russia investigation in early 2017?
Sir, let me see if I can answer that question without getting into operational detail. The investigation was broad. What Russia was doing against our country encompassed a variety of things. There were actions in the cyber arena. There were actions by their agents and their intelligence services. There were actions by subjects of investigation that are currently ongoing. The prospect of how the FBI would investigate that was a multi-tiered effort. And so some of those efforts that traditionally fell into line with that other DAD and their span and scope of responsibility were moved to their supervision.
So the footnote goes on to state that, quote, however, AD Priestap told us that FBI leadership decided to keep Strzok involved in the Russia investigation, and he was therefore reassigned back to it. Do you know who in, quote, FBI leadership, end quote, decided to keep you involved in the Russia investigation?
I do not.
Could it have been Deputy Director McCabe?
Sir, possibly I do not know.
And when were you assigned back to the Russia investigation? And when you were reassigned back to the Russia investigation, were you still in a supervisory role?
Sir, I would answer that question again. I don't entirely, my recollection does not comport with the statement from AD Priestap. There were elements of the investigation that stayed under subordinate leaders and subordinate section chiefs and unit chiefs on down the line. There were elements of it that were transferred to a different DAD and remained with that DAD. So my recollection is a bit different from AD Priestap's.
Mr. Strzok, did you ever consider recusing yourself since you had such personal disdain for the person you were investigating?
I did not.
Yet others did require that ultimately.
Sir, I would not characterize those decisions as subject to the same set of considerations.
You don't think that it was the bias expressed in your text messages that caused Mr. Mueller to remove you from the investigation?
I do not think that that bias was expressed in those text messages. I cannot speak to why Director Mueller chose to remove me from the investigation, but I can tell you that those text messages are not indicative of bias.
Mr. Mueller never told you why you were being removed?
My recollection of the discussion was he mentioned the existence of the text messages, and that based on that, he needed to ask me to return to the FBI.
Lots of people have text messages, Mr. Strzok.
Yes, sir. And my impression, not stated by him, but my impression was that based on the appearance of those messages and in part of a desire by him to avoid even the appearance of any potential bias, that he asked me to return. But that's a question for him.
But he kept everyone else.
Sir, I don't know the staffing decisions that were made by Director Mueller after I departed.
Including 13 Democrats.
Sir, I don't know the affiliation of the people on his team.
So, but he was concerned enough about your text to remove you, but you never felt concerned enough to remove yourself.
That's correct.
Mr. Strzok, you're going to get asked other questions here that relate to your transition from the investigation of Ms. Clinton into the beginnings of this investigation into the Trump campaign and the alleged collusion with the Russian government. Now, Mr. Strzok, the FBI is a creation of this body. Congress created the FBI with its constitutional authority. Today, you are here under subpoena. I know you've come voluntarily in your opinion, but you're also under subpoena, also an exercise of Congress's constitutional authority. Which takes precedence, FBI policy or the United States Constitution?
Sir, always the United States Constitution. My understanding is I am not here under subpoena, that I am here voluntarily. I understand a subpoena was issued for my prior closed interview, but not for this session today.
A subpoena was issued and service of which was accepted.
That's not my understanding, sir.
In a Supreme Court case handed down just last year, the court reviewed whether statements made by a juror that indicated racial bias required the piercing of jury deliberations. Justice Kennedy wrote the opinion of the court holding that racial bias exhibited by a juror provided an exception to the rule that jury deliberations must remain confidential because it is necessary, quote, to ensure that our legal system remains capable of coming ever closer to the promise of equal treatment under the law that is so central to a functioning democracy. On several occasions, you have referenced that all the texts in the questions were simply personal opinions exchanged with a close confidant and in no way reflected your intent to act on your opinions. Yet, if you made these statements while on a jury, it is hard to imagine that you would not be kicked off immediately because of the risk that your bias would undermine a functioning democracy. Do you still hold that personal opinions, even in the face of Supreme Court precedent, should not have tainted your involvement on any investigation relating to Secretary Clinton or President Trump?
Mr. Chairman, I think you're mixing apples and oranges. I'm not an attorney, and I'm not familiar with that Supreme Court ruling. But based on what you said, protected categories, things like race, gender, ethnicity, sexual orientation, religion, are protected matters that we may not, the government and by law, people may not be discriminated against based on their role one way or the other in any one of those categories. That is entirely separate and distinct from political belief or political opinion. That, on the other hand, is encouraged, is protected by the First Amendment. And this body, under the Hatch Act, my understanding is, sat and said and recognized—
No one stopped you from sending the text, Mr. Strzok, but the special counsel, Mr. Mueller, removed you from the investigation when he saw the texts.
That's true, sir, he did. Now, if I may
Thank
go
you.
back to answering your question, if I may. In terms of political speech, that is radically different from any sort of protected category of race, gender, and ethnicity or other categories. Political speech, political thought is protected. The courts have recognized, the Constitution recognizes we all have political belief. And so when it comes to the expression of that political belief, that is something that this body, under the Hatch Act, enumerated kind of the categories of what was prohibited, and then expressly stated that if it is not prohibited, then it is expressly encouraged. So I would tell you that no one in here, it's an impossible definition to say people must not have political opinion. Everyone does. Of course they do. The test is whether or not that is left behind when you're doing your job. To your question of whether or not I would express that in front of a jury, of course I wouldn't. That would be inappropriate. As to your question of whether each and every one of those jurors, when they go home and they're sitting in their backyard with a friend, has a political opinion, my answer would be undoubtedly, almost if not all of those jurors would.
But they're instructed when they leave the jury panel each day to not communicate with anyone regarding the matter that they are considering. So that is a very different thing. You were considering a matter and you were conducting texts of a very biased, salacious manner that was totally inappropriate. And when Mr. Mueller saw that, he removed you.
Sir, I appreciate that concern. But what I'm telling you is there is a vast difference in my mind between an action as a juror being instructed by a judge not to discuss the matters of a trial compared to a citizen of the United States.
You don't suppose there's a reason why
discussing his personal
You don't suppose there's a reason why that instruction made? So the chair recognizes the gentleman from New York, Mr. Nadler.